special magistrate code enforcement meeting of the City of St. Pete Beach for Monday, July 13th at 10 a.m. My name is Erica Agello, and I am the appointed special magistrate to hear today's cases. I am a practicing attorney licensed by the Florida Bar and board certified in city, county, and local government law. I have been appointed to this position in accordance with the authority set forth in Chapter 162 Florida statutes and the City of St. Pete Beach Code of Ordinances. I am not an employee of the City of St. Pete Beach, and I do not represent the city here today. And I do not confer with the city's code enforcement officers outside of the hearing process about your cases. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order on which they appear on the agenda unless otherwise agreed. Every effort will be made to hear all persons having relevant evidence, arguments, or comments related to the specific case that is being heard. If you wish to speak today, it is necessary that you will be sworn in, which I will do momentarily. All testimony given will be done so under oath, and in all cases, since the city has the burden of proof, the city will present its case first. The respondent will then be given an opportunity to refute the city's allegations. Though formal rules of evidence do not apply to this proceeding, I will make every effort to ensure that fundamental fairness and due process is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing, and all parties will be provided with a copy. So please ensure that we have your current address or email address. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether a city code has been violated, and under some circumstances to provide a reasonable time to correct the violation by whatever means are available to you. Please be advised that you may be subject to a fine, and a lien may be recorded on your property if the violation is not corrected by the compliance deadline, if one is provided. If you wish to present any evidence today, please sign in at the podium before you speak, and it will be necessary that you swear or affirm to tell the truth. Therefore, at this time, I will swear in any witnesses. Anyone wishing to speak today, if you could please stand and raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, so sworn. Okay, do we have any changes to the agenda this morning, Mr. Dewar?
Yes. Good morning, Madam Special Magistrate Pete Dewar, Code Enforcement Manager for the City of St. Pete Beach. Are you okay?
Yeah, I'm good.
Case number 2026-0104. It's under I, new case I. It should be under repeat violations. Case number 2026-0129. 618 78th Avenue. An update to provide survey quotes for offense.
Okay, so we have the case number 2026-0104 is a repeat violation, so we just need to move that underneath that heading. Is that correct?
I'm sorry, 0104?
Yeah.
Yes, please.
Okay, and then the second case that you just said?
We're going to do it administratively, never mind.
Okay. Never mind.
2026-0257, 809 Gulfway. Status hearing for repeat violation on turtle lights. That never made it to the agenda.
Okay, I'm sorry, it's not on the agenda, so what is the?
2026-0257, 809 Gulfway. You ordered that it come back for repeat violation, for status hearing. Yes, ma'am.
Okay, so we'll add that as 3D.
Thank you.
Okay, any other changes to the agenda?
No, ma'am. Thank you.
Okay. Okay, then moving on to the first item on the agenda, agenda item 3A, case number 20250177, City of St. Pete Beach versus Chris Spencer.
Good morning, Special Magistrate Ayaka Rakshel, representing the City of St. Pete Beach. This case, per your last order dated June 8th, you gave Mr. Spencer 30 days till July 8th to secure a permit. The contractor did come in on June 30th and put in the application. However, as of this morning, the permit is still in review. It has been denied by the building department and the planning department and requests additional scope of work.
Okay. And the fence has still not been removed, is that correct?
Correct.
Because I think I gave the alternative that either was securing an after-the-fact permit or removal of the fence, so there was another means of compliance. So the property still is out of compliance.
Correct.
Okay. All right, anyone here on behalf of the respondent? Mr. Spencer, or anyone here on behalf of Mr. Spencer? Have you had any contact with Mr. Spencer at all?
No, none at all.
Okay. All right, and what is the city requesting as far as fines?
Requesting $250 a day fine from your compliance date after the date after your compliance date, which was July 8th, so starting July 9th.
Okay, and administrative fines, what does that amount?
Correct, $330.
Okay, and the city would like the recording fees?
Correct.
Okay. All right, I find that the property is still in violation and also in violation of my final administrative order. I will assess a fine, of $250 a day beginning on July 9th until the property comes into compliance. It is the respondent's responsibility to notify the city's code enforcement department when the property is in compliance. I am going to assess the $330 in administrative costs of the city, as well as any recording fees necessary to effectuate a lien on the property. All right, moving on to agenda item 3B, case number 2025079, City of St. Pete Beach versus Paulette Bosella.
Good morning, Madam Magistrate, Steve Rivera, City of St. Pete Beach Code Enforcement. This was a status hearing for Ms. Bosella to pull permits for the AC split units that were installed. She's been going back and forth with the historic board, and now she is waiting for, let me pull this email up here. I have an email from Brandon Berry. She's supposed to come back now to obtain a variance for the setbacks. So that's not scheduled until the end of August, so we'd like to continue this to the September hearing, 9/14, I believe it is. 9/14.
Okay.
She's working toward compliance. At this point, she's kind of held up with the city.
With the city?
With the hearings.
Okay, all right, and Ms. Bosella, is she, I don't see her in the audience.
I don't see her
Okay.
today.
And Ms. Bosella is okay, I'm assuming, with continuing the hearing?
Brandon Berry's been in conversation. We can kind of relay messages back and forth. That's who sent me the email saying that she needs the variance for the setbacks.
Okay,
So she's aware of what's going on. I could reach out to her after the hearing.
okay, well, and I'll send her an order of continuance regarding the same. So since there's no objection to the continuance and Ms. Bosella is making a good faith effort to comply with my order as well as the city's code, we will continue this case until 9/14 at 10 a.m.
Thank you.
All right, moving on to agenda item 3C, case number 20260138, City of St. Pete Beach versus Timothy Wheeler and William J. Dudley, or the estate of William J. Dudley.
Good morning, Special Magistrate Officer Lucy Knight. I'm asking for continuance to August 10th for this one case.
Okay, and have you spoken with the property owner? Is the property owner here? Anyone here on behalf of Mr. Wheeler? Or, okay, if you could come forward. Do you have any objection to continuing this case until August?
No, we've been in communication. We have some documents, things I'm sure they want to review.
Okay, perfect. Okay, well then I will go ahead and continue this case until the August 10th magistrate hearing at 10 a.m. And hopefully you guys will be able to figure it out before then. All right, and then moving to the new addition to the agenda, item 3D, case number 20260257, 809 Gulf Way.
Thank you, Madam Magistrate. Steve Rivera again, City of St. Pete Beach Code Enforcement. This was a status hearing for the turtle lights that were a repeat violation. I have a copy of your order since it didn't make it to the agenda. Can you overhead, please? So this was your order that was from the June 8th hearing. And then here's the back where you gave them until July 8th to come into compliance. So the property is in compliance. The photo here, you can see where the lights now, you can't see them. Everything up here has been turned off. The lights that you can see up here are compliant. They're turtle light compliant.
Okay.
Being that it was a repeat violation, I know you gave them until the 8th. We're asking for 1 day of a violation of $500 for the 1 day plus the $330 in administrative costs. He did email me the next day to tell me that he was in compliance. It was the day after the hearing.
Yeah, I think the picture was June 8th on that, so,
July.
July 8th, sorry.
Yeah.
Missing a whole
Yeah,
month.
July, I'm sorry, June 7th.
June
It's this
7th.
photo, but the photo that, should have said July 7th, I printed out the wrong picture, but it's the same picture.
Okay,
But he was in compliance next day. I didn't get out there to inspect it until that 7th of July, actually.
okay.
That's where I got the dates, even though he had to the 8th. But we're asking for 1 day of the violation, being that it was a repeat.
Okay, can you put my order up there? Because I don't
Yes.
believe I treated it as a repeat violation.
No, and that was the confusion, I believe.
Right, because technically it was a repeat violation, however,
You want the front or the back here where you gave him till the date?
you can leave that there. Yeah, okay, I recall that now, because he would have been in compliance regardless. It wouldn't necessarily have been a repeat violation, considering there was a change in the topography of the dunes. It was really no fault of his own, it was fault of the topography around him. Okay,
Pretty much, yeah.
so I am, is anyone here on behalf of Hurricane Lounge? You said he just emailed you the
Yeah,
photo.
so we had another case that we were addressing that he took care of for me as well. He emailed me, he actually emailed Jen, our administrative assistant,
Right.
the next day. She forwarded the email to me. I got out there on July 7th to do the follow-up inspection, being that he had till the 8th. He was in compliance, so I'm giving him the benefit of the doubt that it was in compliance on June the 9th. And that was the request for the 1 day for the violation.
Right, okay. All right, I am going to find that the property is in compliance. Because I did not treat it as a repeat violation due to the change in topography, I'm not going to allow the $500 fine, but I will do the $330 in reasonable administrative costs of the city.
Thank you.
Okay, and moving on to agenda item, new cases, agenda item 4A 20260350, City of St. Pete Beach versus Ariel Lenzi.
Steve Rivera again, City of St. Pete Beach Code Enforcement. This is case number 20260350. Respondent is Ariel Ignacio Lenzi. Forgive me if I said that wrong. Violation address is 195 45th Ave. Violation description: the property is in violation of Section 9.2, Principal Uses and Structures of the Land Development Code of the City of St. Pete Beach. Case summary: initial inspection was 6/23/2026. Notice of violation dated and mailed certified 6/24/2026. Notice of hearing dated and posted to the property 6/24/2026. The following is a true and accurate representation of what I witnessed. This is the affidavit of posting at 195 45th Ave. This is a screenshot of the Airbnb ad. This is the Airbnb host information and nightly cost. These are the 4 reviews in violation. If you look, the first one from Ashley shows stayed a few nights. There's one from Melissa, says stayed a few nights. Dana stayed a few nights, and Jennifer also stayed a few nights. It's the Airbnb review policy. Corrective action: the property can only be rented monthly. The property is now compliant, showing 30-day rental only. Recommended fine is $1,000 per review for the 4 reviews, totaling $4,000, plus the $330 administrative costs and any recording fees that may be associated with this case. And that concludes my presentation.
Okay, thank you, Mr. Rivera. Anyone here on behalf of the property owner, Ariel Lenzi? Okay, if you could please come up, state your name and affiliation with the property owner for the record, and you may respond to the city's allegations. Good morning. And your name?
So my English is bad, so is possible translator?
I'll allow for purposes of this proceeding. And what is your name, sir?
My name is Christian Shepherd.
I'm sorry.
Christian Shepherd.
And your last name, could you spell that for me?
SCHEFER.
Okay. And who do you have with you here today?
Ariel Lenz.
Okay, so that is the property owner.
Yes.
Okay, and can you ask him, does he allow you to speak on his behalf? Okay. All right, and go ahead and let me know what's going on with the property.
He purchased the property. He didn't know about the code he's sorry. As soon as he received the letter, right away he fixed it. He changed the Airbnb to 30-day plus now, and he also sent an email to the city letting them know that we corrected, and anything else that we need to comply, not to have any fine, to let us know. But they told us that we had to come here today.
Okay, and how long has he owned the property?
2 months.
2 months, okay. And did he purchase it with the intent of using it as a short-term rental?
Yes. Yes, ma'am.
And did you do any due diligence with the city to figure out if you were even allowed to do that within the city?
No, ma'am.
Okay. Okay, and it looks like, just based on the Airbnb ad, you were charging about $300 a night or $250 a night, is that correct?
Yes.
Okay, and you had 4 rentals during that period of time. Do you know how much money you made on each of those rentals?
Probably about $2,000
On each one?
More.
Okay. Okay, anything else there is that you'd like me to know?
No, we have the proof that we cancel all the future
The future
reservations.
reservations, okay.
And the people asking what happened, that we cancel, we explain the situation. And like I said, we even have a 30 days reservation that we cancel because we want to start from the beginning and doing the right things. And that's all.
Okay, I would suggest that you leave that proof with the city. I don't necessarily need it, but they'll probably need it for you in order to comply with the order that I draft. Thank you very much. All right, anything else from the city?
Nothing further, ma'am.
Okay, so the city is asking, the city has determined that this is an irreparable or irrevocable violation, and I tend to agree. So I'm going to find that there is a violation of the stated code section. It is irrevocable or irreparable. There were 4 violations of the city's short-term rental code. I am not going to assess the $1,000 per each rental, but I am going to assess the $500 per each rental based on the credible testimony. There was about $8,000 that was made on those 4 rentals. So it will be $500 for each rental for a total of $4,000, plus the $330 in reasonable administrative costs of the city and any fees that will be incurred as a result of recording a lien on the property. I would go ahead and get with the city on that one. Also, part of my order is going to say cannot rent the property less than 30 days. It looks like you guys have already taken care of that. And to provide the city with proof that there are no short-term rentals on the books, which is why I said you might want to provide that to Mr. Rivera. Just make sure I have your contact information. I will get you an order to that effect, and then just continue to speak with the city if you have any questions on that.
Madam Magistrate, real quick for the record, if you said 4,000, 500 times.
I'm sorry, 2,000.
Yeah, I just wanted on the record.
I actually had my my calculator out, so yeah. Thank you.
No,
it's Monday.
Stephen, why would you admit that?
It was going to come out sooner or later. I am not good at math. All right. Thank you very much. All right. We're moving on to 4B, case number 20260245, City of St. Pete Beach versus LCP South Postcard Inn LLC.
Madam Magistrate, for this particular case, our code officer will make her presentation, as we generally do. We will have one witness, I believe, Lizette Naoli, who we will be bringing to you as the city's witness for additional information.
Okay, thank you.
Hey, good morning, Special Magistrate Ayaka Rochelle, representing the City of St. Pete Beach. This is case number 202600245. The respondent is LCP Postcard Inn LLC. The violation address is at 6300 Gulf Boulevard. The violation description: the property is in violations of sections 46-132A, 1, B, C, and 2, sound level limitations of the Code of Ordinances of the City of St. Pete Beach. Case summary: the initial sound readings were on May 7th, 2026. A courtesy notice was dated and mailed certified on May 13th, 2026. A notice of violation was dated and mailed certified June 2nd, 2026, and the second sound readings were taken on June 29th, 2026. Notice of hearing dated and posted on the property July 1st, 2026. This is the affidavit. This is a true and accurate description of what I witnessed. This is the affidavit of posting July 1st on the property, 6300 Gulf Boulevard. On the first sound reading date taken on May 7th, this is the summary report that indicated that there was one property found in violation. Note that the time of this was taken during the day, and so the parameter at that time was greater than 50 decibels. I do want to put into the record the overhead, please. Overhead, please. Okay, so this is the certificate of calibration for the instrument that we use. It was just redone on June 15th, 2026. So the machine is calibrated correctly. And for the record also, the individual sound readings taken at 5 different apartments are posted here. What I have in the presentation is the summary report with all the individual reports from each apartment is indicated here. Would you like me to go through the methodology of how we came up with the violations or not?
Yes, please.
Okay.
And could you show us the survey with the violation and tell us how you measured it?
Okay, so this was taken on May 7th, and this was the violation found at apartment number 402. Both 2 officers were present, myself and Lucy Knight, and the instrument was calibrated first, as indicated here by the start indications, and the environmental conditions were also noted at the time. The way we do our sound readings is we take basically an ambient sound reading first, which is the background surrounding noise that lacks the violating sound. That is recorded, and then we add the sound back into the calculation, and we take a noise source level reading. The difference between those 2 levels gives us our adjustment factor, as you can see here. The ambient sound reading was 51.4 decibels, and the noise reading was 58.6. The difference between them indicated 7.2. We refer down to the chart here. If we have a difference of 7.2, we adjust the source reading by 1 decibel. So consequently, 58.6 minus 1 brought it to 57.6, which was in excess of the 50 decibel maximum limit.
And just for clarity on this one, even with the adjustment, the ambient noise level is still exceeding the 50 decibels that were there, so any additional source noise would have bumped it over the, is that correct?
Correct.
Correct.
Correct. Yes. So that was for that. Out of the 5 readings that we took on that day, it was just the one apartment that indicated there was a violation. The others 4 did not.
Could you introduce the meter that you showed that was calibrated, please?
See this on the overhead, or do I need to show the stick?
Put it on the overhead so everyone can see that we have a noise meter, and that meter is calibrated yearly. Thank you.
Okay, so I'll go back to the presentation. So that was the summary report as I just described to you. This is the HVAC unit that sits on the roof that's producing the noise. Taken from different angles, close to the building.
Do we know if this is a fairly recently installed HVAC unit, or has this been in?
It is. It's an upgrade. The hotel has just been reopened again as of last month, and so this is a new installation, I understand. Yes. After we had been talking with the engineers there, and they were voluntarily trying to work with us to come and see what methods they could use to dampen the sound. And on June 27th, we spoke with the engineer and said that they had voluntarily installed blankets to try and dampen the sound. So we took the initiative and took another sound reading to see if that would make a difference, and that was taken on June 29th. This time, the time of that reading was done at 6 a.m. in the morning to basically look at the nighttime hour parameter, which is reduced now to a maximum of 45 decibels. Okay? And in that study there, we see that all 5 of the apartments were exceeded the 45 decibel limit. Again, using the same methodology. I do have the individual reports here, or the overhead of each apartment, how it was calculated, as explained previously.
And then again, on those 5 apartments, it looks like for the nighttime, it exceeds the nighttime decibel rating, but it also exceeds the daytime decibel rating. However, that doesn't account for the ambient noise that occurs during the day. Okay, understood.
All right, back to the overhead. To the presentation. So that is that report. So the corrective action is the property must not exceed the sound level limits for the multifamily dwelling units. It's table 2, whether it be day or night, 45 decibel or 50 decibels. The property is not compliant, and so the recommended fine is $250 a day from the date of your order, plus 330 administrative costs and any recording fees that may be associated with this case. I do want to make a note, though, that they have been working diligently trying to rectify this problem. They are voluntarily working towards compliance. Their next resolution is to come up with a silencer of some type, but that has to be engineered and designed. And that time frame is sort of unknown at this point in time.
Okay, so do you know, as you sit here today, if the daytime decibel levels based on the blanketing have been reduced and it's now just the nighttime levels that are exceeding the DBAs in the code? Because the first reading was taken during the day and showed that it exceeded the daytime levels.
Right.
I don't know if at that time exceeded the nighttime levels. I can make an assumption, but I don't know what those ambient noise levels were at the time.
Right, without measuring accurately, I couldn't tell you specifically.
Okay, but at this time, there is proof that it demonstrates that all 5 of those readings from all 5 of those
Correct, at
apartments
night.
exceed the nighttime level, even with the blanketing.
Yes.
Okay. All right, anyone here on behalf of the property owner?
Your Honor, we still have, we have a witness, and we also have a number of affidavits that we would like to include in the record as well. Our officer can briefly describe them.
So these are affidavits from the residents and the
Could you state
property
their
manager.
names? Just read the names for each affidavit.
Mayor Kaverick is the property manager there. And then we have residences, I believe, Bob Thrush.
Please put them on the overhead.
Mark Pendlebury. Pamela Shorttree. Lizette Natoli. Kurt Haffey, I believe. Carol, looks like Malta or something, Mala. And Christina Spencer. 8 affidavits here that are...
The essence of the affidavits is basically based on their personal knowledge and their observations. And at this time, Your Honor, we would like to go ahead and call Lizette Natoli.
All right, and the affidavits will be entered into evidence. If I could get a copy of those,
Right.
I'd appreciate it. If you could please state your name for the
Yes,
record.
my name is Lisette Natoli, and I have been a part-time resident at the Silver Sands since 1988. My unit was one of the units that the reading was taken from early in the morning. So I am very familiar with the property of the Luce Hotel. When we heard that there was going to be a renovation done, we were thrilled. And I think I can speak for all of the residents. We thought, it's wonderful, we're going to have a nice hotel next door, possibly a nice restaurant, beautiful landscaping, and we were excited. And throughout the 2 years, Madam, that the construction was taking place, we never once complained. We were hopeful that, you know, there would be an end to it. But today we have a really serious issue. The noise that is emanating from those 2 rooftop chillers, it's not just a hum, it's not just a push. I would describe it as a roar. It is literally impacting the quality of our lives during the day as well as in the evening. My husband and I, and I'm sure a lot of the residents, love to sit outside on our balcony and have our morning coffee. We are unable to stay on our balconies. The noise is so disruptive. Your Honor, we cannot even hear the birds. That is how loud that noise is. It is life-changing and impacting our, enjoyment of our unit. When we enter inside, we close our sliding glass doors. When we're in our living room, we still hear the humming. At night, when it is time for us to go to sleep, we close our sliders and we literally have to lower our hurricane shutters in order to be able to sleep, and we still hear the humming. It's not just our stack that is being impacted, the entire side of the building, as well as the interior. We have a lovely open-air atrium. We cannot be in the atrium without hearing the whooshing from the chillers. And there are 2 chillers, it's not just one. So the noise that they are making is very significant. Our lobby, you can hear the humming. In the parking lot, I was by the pool yesterday and someone said, I was walking my dog, and what is that noise we're hearing? They didn't know where that sound was coming from. The quality of our lives has been negatively impacted. And I just want to say, I love the Silver Sands. I love St. Pete Beach. It's a beautiful, family-oriented community. We want to be good neighbors to the Luce, but they have to be good neighbors to us also. This has been dragging on and on, and we have no relief. Since this started, we have had no relief from the noise. And I just want to say shame on them. They know it has to be fixed. They should be fixing it. It has been long enough. Please help us to remedy this situation.
Okay.
Thank you.
Nothing further.
Nothing further from the city. Okay. Is there anyone here on behalf of the respondent? Okay. And prior to giving whatever presentation, do you wish to inquire of the city's witnesses at all?
Not to make this a contentious hearing, but I would object to the entire testimony. The city didn't ask a single question. And so the witness just basically testified on their own without any direction from the city, without any objective testimony.
Sure, and I can understand that. However, this is not a formal proceeding in that type of scenario. I note your objection for the record. Okay. And if I could get your name for the record as well?
Yes, Kevin Reale. I'm with Stearns Weaver Miller Law Firm, 401 East Jackson Street, Tampa. And I signed in the back, so you have my email address.
Appreciate that.
We do not contest the city's measurements, and so all the formality that the city covered with the decibel readings and those measurements, we can stipulate to those and move on, because really my discussion with you today is going to be twofold. One is going to talk about the violation itself, and then 2, talk about what we've been doing to remedy. And I have the hotel manager here to talk about that with some more detail as well. I'll start with the more formal part of this first, and then we can talk about resolution after. But the city has cited in the violation section 46-132, and they talk about A1, and specifically C is mentioned, and it talks about decibel limits of 45 and 50 for night and day respectively. That's not the limit for the property here. The property here is governed by section 46-132A2, which is then governed by the limits in subsection B, Table 1. Subsection C is for noise within a multifamily dwelling, and I'll quote here from the code in subsection C: in a multifamily dwelling, no person, et cetera, et cetera, et cetera. And then it talks about set forth in Table 2. And then Table 2 talks about sound limits within receiving multifamily dwelling unit. This is for noises in between two units in a condominium. It is not for noises on a receiving property. In subsection A, 46132A, you can see that it talks about, I won't quote that section. That's the section we're governed by. And then you have subsections 1 and 2. 1 is a generic receiving property, which is the property line. And then 2 gives a very specific location of properties along Gulf Boulevard. So this property is under A2. And so it is measured at the building or 30 feet in. So we agree under A2 that this measurement was taken in the right place. And we agree that the measurement was taken properly. But the limit is not 45 and 50. The limit is 55 and 65. And so that does create an issue for the notice today. I think we can get past that probably with just a renoticing, and we'll probably have to come back to you. But it's really important to us because that 45, 50 decibel limit needs to be, it's not the level that the property needs to be held to. It is the 55 and 65. And so while in some manner this is a technicality, it's not a technicality on those levels. That's very important to us. And so that's a very long way of me saying there is a problem with the notice. We're not fussing about the notice particularly. It will have to be renoticed because we need to use the proper procedure here. But the 45 and 50 is not the limit that the property needs to be held to when this violation is updated.
Okay.
I'll stop there and see if you have any questions.
I was going to say, I'm going to stop there and see if the city council would like to respond to that at all.
Your Honor, we are looking at the section that has been cited, and with all due respect, of course, we would disagree on the record with the interpretation. However, the city's main goal in this situation, as you've heard from our witness, is really to come to some type of resolution and bring this property into compliance, whether it's noise that's being emanated between units or from other properties to the unit. Regardless, it is an unfortunate situation. So our preference would be to remedy it and focus more on the remedy. With that said, even if there were to be a violation found today, our recommendation would be to bring it back at your next meeting to further address the level of compliance and a status, which means we would be coming back in 30 days anyway. Just to clarify the record and make sure that we've addressed everything. We could go ahead and renotice it, but still, if we renotice it, we're still coming back to you in 30 days.
And I can understand that, and while that might be a practical matter, from a legal perspective, it will depend on whether or not that there's a violation found. Understanding I know what the readings are, and I know that it's kind of irrelevant with the 55 and 65, but it does matter for compliance. And so, to the respondent's point, the notice is legally sufficient in that they're here, so they've got notice of the violation, but of which violation? So if the parties, if the city's holding firm to the section cited is the appropriate section, then I can certainly take a look at it and I can make a ruling based on that. If the city is not holding tight to that and the city is willing to amend the notice as we sit here today, or you guys can stipulate to whatever the proper section is, I can certainly do that, and then we can move forward with whatever the remedy is.
We would be agreeable to amending, and if they want to stipulate that that the referenced citation is the correct one. Again, the city's interest is really trying to get this thing resolved.
For compliance, and I understand for my purposes it matters because compliance is going to look a little different underneath one or the other, and from a violation perspective.
So the easier, if I may, Your Honor, the stipulation would be the easiest. If not, we would amend it at this time.
I can provide a memorandum of law and follow up if you want. We absolutely do not agree that the limit is 45 and 50, period. So notice is not what I'm fussing about here.
It's the particular violation.
It's the violation, right?
So if the notice of violation were amended to reflect not the 46.132A1 and then the C, but instead the A2 and then the B section of Table 1, that would be sufficient for you?
Correct. But again, that's not, right, that changes what the measurement requirements are, right?
It changes the measurement requirements. It doesn't change the evidence sufficient enough to prove the measurement.
Correct. And to be clear, that's why
So you would still be in violation?
we would be in violation for nighttime.
For the nighttime one, correct. Correct. And because we don't have a measurement on whether or not you're in compliance after the blankets with the daytime measurement, right now I'm just focusing on the nighttime measurement.
And that's, so that we can for sure stipulate, because what I don't want is this back and forth to make it seem like we're not, because we're going to get to the trying to be good neighbors part after this.
Right.
But it's very important for the 55 and 65 from our point of view, not the 45-50.
Understood. Is the city willing to agree at this time, and if you're not, that's fine, but is the city willing to agree at this time that the applicable code section that would apply to this violation is in fact the 46.132A sub 2 and then B underneath Table 1?
Yes, Your Honor, we will.
Okay. And so the parties will agree on the record that the notice is now orally amended to reflect that particular section for code violation.
Agreed.
Okay. All right. So then we will proceed moving under a violation for 46.132 subsection A2, with the reference numbers being under Table 1, Section B, which is the 55 and 65 respectively.
Correct. Thank you.
Okay.
So if that's agreed, I'll move on to compliance, and I do have the hotel manager to talk about that. And I appreciate the testimony from the neighbor and their understanding in the rebuilding and rebanding of the hotel after the hurricanes, because it's not been an easy process. I'm actually primarily working with the hotel on land use and permitting, and I'm helping them with this because it has been a challenge, because the hotel's old, and so there's FEMA compliance and fire marshal compliance is very challenging. Here, the AC units that were installed, and I will submit this to the record, this is the engineer that they hired, it's signed by a professional engineer. The units are not supposed to be this loud. The manufacturing data card shows that it would be, and now these manufacturing data cards, you have to understand, they are measured right at the unit, so it's about 5 feet off. So the numbers, and I'll make sure I quote the right ones, but please refer to what I submit here for it. But the manufacturing data puts it somewhere around 70 decibels right at the unit. And then the engineer went through and did a calculation on how that should abate over the distance between where the measurement was taken and where the unit is located. And the units should be reading at 42 decibels, and they're clearly not, right? And again, we've stipulated to that, and that's not a concern. And so the first attempt that was done is to get the manufacturer out. The manufacturer admitted that the fans are running louder than they're supposed to, and so at that point, the engineer was hired to basically come up with a solution. The first solution that we thought would work would be the blankets. It's not working, and so now basically a fully engineered solution is going to have to be installed around that's going to dampen the sound. That is underway, but it's basically a uniquely engineered product, so it has to be engineered and then built. And so the problem here is the timeliness of compliance, because the engineers are still working on that part right now, and I don't know, do I hand it to you or to the clerk?
You can hand it to Ms. Ruffishall.
And then, so as far as working towards compliance, that started before the violation. We got the courtesy notice. The engineers were working with the code enforcement staff. We do want this to be better. We want it to be better for the hotel. We want it to be better for the neighbors. It's not supposed to be operating this way. It's a very expensive unit that you're supposed to be able to trust the manufacturing data card. Going back and suing the manufacturer is not going to help anyone here. And so we're trying to find an engineered solution. It's definitely costing the hotel money. So this is not them trying not to spend money. They were not trying to cut a corner with the install, as the engineer's letter can identify for you. So with that, we are going to ask for time, whatever time if we come back in 30 days, and then we can give you a status update of where the engineer is on that, and then we could discuss, what time compliance should be set out on that. That would be our request, and I did speak to the city attorney about something similar to that. You can please confirm with her, but that would be our request. And then if you do have any questions of hotel management, they're here for any specifics on what's been done. I only understand what the engineer has reported in that letter that you're submitting.
Okay, so I guess my question would be, an engineered solution, understanding it takes time, do you have an anticipated amount of time that anyone has given you, any type of I don't know, outset that they're looking at?
I don't have, do you have that yet?
We don't have it yet. Yeah, we don't
I
have.
apologize. And what is your name, sir?
My name is Jeremy De Silva, General Manager of the Luce Hotel.
Okay, thank you very much. Okay, so there's no estimated time for any type of engineered solution to this?
Not at this time. At first, it was them doing the discovery because originally, like was said, is the unit shouldn't be, operating at the noise level. So they came out on a couple occasions to do their own readings to just get an overall assessment. At this time, the same engineer team who was a part of rebuilding the hotel is actively working on this to come up with, it's a unique solution to a unique problem that we're experiencing.
Okay, and is the manufacturer involved at all trying to get solutions for this? I mean, not that you guys need to, but just out of curiosity.
I know the engineer on record is working directly with the manufacturer because I think they were also in agreement too. If like something's happening, we don't know what it is, and then that team needs to figure it out. Smarter minds.
Okay, and I know the solution of you can't stop running the HVAC units. You've got units that need to be cooled. Is there anything that can be temporarily done until such time as the engineered solution can be rectified?
Yeah, we installed the blankets. That was our first attempt to just soften them, but I don't know that it made the impact that we were all hoping for.
But are they still there?
Oh, yeah.
Okay.
Yeah, and they will remain.
Until such time as there's another solution. Okay. Okay. Yeah. Okay. Anything else that you guys have? Or any inquiries that you'd like to make of the city or its witness?
No, I put an objection for the record, but again, more of a formality. Thank you.
Understood. Thank you. And Ms. Rectichel, anything further from the city?
This time, thank you.
Okay. I am going to find that there is a violation of the amended section, the amended notice of violation of 46.132A2, Table 1, subsection B, with regard to the nighttime violation, the 65 decibel, well, with regard to the noise violation. I'm going to leave it just blank on the decibel level. I am going to just call for a status hearing in 30 days. I'm not going to give a definitive date for compliance, as there is a good faith effort being made towards trying to remedy the situation. But I will say that with caution. Understanding engineered solutions may take a while. It is not an indefinite open-ended date. So I'm going to set the case status hearing for 30 days from today. Well, not 30 days, but for the next hearing, which is August 10th at 10 a.m. We will be back here to see where we are, and I'm going to ask the respondent to make every effort possible to get us an estimated date when that engineered solution might be available. Otherwise, I'm going to have to set some sort of arbitrary date for compliance, because the parties are in need of some sort of resolution. I don't just mean the respondent in the city, but also the third-party residents, and that might be able to perhaps give the engineers a little bit more incentive to work faster, though maybe not. You can only do what you can do. So I will get an order out to that effect, and then I just encourage the parties to continue working together to come to a resolution of this matter. Okay. Moving on to 4C, case number 2026-0169, City of St. Pete Beach versus Inam Ibrahim.
Ayaka Ruckshell, representing the City of St. Pete Beach, Code Enforcement. This is case number 2026-0169. The respondent is Inam Ibrahim. The violation address is 424 88th Avenue. Violation description: the property is in violations of sections 8.2, permitted principal uses and structures of the Land Development Code of the City of St. Pete Beach. The case summary: the initial inspection took place on March 30th, 26. A notice of violation was dated and mail certified June 24th, 2026, and a notice of hearing dated and posted on the property on June 24th, 2026. This is a true and accurate description of what I witnessed. The affidavit of posting on June 24th at the property address. This is the Airbnb advertisement for the property. This screen here shows the Airbnb five-night reservation and the associated cost with that. There is only one review, and that was dated in September 25th from Zena. September of 2025, I should say, not September 25th. This is the Airbnb review policy. And the corrective action is the property can only be rented monthly. The property is not compliant. The recommended fine is $1,000 per review. It's only one review totaling $1,000 plus $330 administrative costs and any recording fees that may be associated with this case. That concludes my presentation.
Okay, so I have a question. On this property, you said there is only one review on the property, period?
Correct, at this time.
Okay, and the only review is for one night stay in September of 2025? Okay, and then,
Within a year now.
okay. And then there's no, okay, that's good. Okay, thank you. Anyone here on behalf of the property owner? You could come up and state your name for the record. And if you could just verify that you've been sworn in.
Yes, ma'am, I have. My name's Beverly Bogus.
Okay, and your last name is B-O?
G-G-E-S-S.
Okay, and Ms. Bogus, what is your affiliation with the property owner?
I'm sister, and I take care of the house.
Okay, and do you have her, or her nom is?
She's here with us,
Okay.
yeah.
Okay, do you have her authority to speak on your behalf today?
Yes, ma'am.
Okay, thank you. All right, and Ms. Bogus, go ahead and whatever presentation you'd like to make.
I'm not sure what the violation was.
So the violation is for short-term rental being conducted on a property in a zoning district that does not allow for a short-term rental. There was a
Right.
one-night stay and a review for a one-night stay on the Airbnb platform.
in September, which we already came and spoke to you about and were fined for. So I'm not sure why we're back for that.
What, do you have the case number or anything on that?
I don't think, do we have any, it's in your email probably. I feel like we were here like maybe October-ish last year for this.
Property address 424D.
Yeah, she has the receipt.
I appreciate that. I actually do have an order that's dated December, let's see, it looks like it's dated December 8th, 2025. It is for the violation for one stay. It was for a trial run. The person who stayed was a family member and a cousin, and money did not exchange hands. I do recall that
That is
case.
correct, ma'am.
Anything from the city on this one?
I'm just checking the date to see when the reservation was. That was on March 30th of 26, showing that there's still possible to date, book a 5-night stay.
We have changed that to the 30-day. I don't know why it's showing that, but we are at 30
So as of March 30th, if you look at the bottom of the screen.
Can you exode that? What is that?
It's Copilot, which is super unhelpful, so.
Yeah, there you
Okay, so as of this 5-night reservation and cost, you look in the bottom right-hand corner, which I haven't circled. That's as of March 30th, 2026.
And what date is the,
The one-night review was.
no, what date is the notice of violation for?
Probably for the same review.
No, not, what date is the date of the notice of violation?
June 24th.
Okay. And what date was the advertisement changed? It was back in 2025?
Yeah, I don't recall when I changed it, but we set the calendar for 30 days because it was on a 0 to 365.
Sure.
Which I think is their standard thing. So we did go in and change it to 30 days, and we've only had one 30-day guest, which was in February.
Okay.
Other than that, it's just it's our family. You know, we're currently staying there, my husband and I, actually. So it's our family kind of staycation place.
Did you call the city at all when you got this violation and let them know?
Man, we've been out of the country. We just returned from a couple weeks in Italy, and then I had a pulmonary embolism on an airplane and spent a week in ICU in Canada, so we're just getting home.
I am so sorry to hear that. Okay. Understanding that on Airbnb you can go ahead and, well, let me ask you this, Ms. Rectoshell. Did you go ahead and try and book the property for less than the 30 days? Not just quote a price for the 2 days, but actually book the property for less than 30 days?
No, I just proceed as far as this screen goes to show that it's capable of doing a short-term rental. I don't actually hit the button reserve.
Okay. And per Airbnb's guidelines, or the functioning of Airbnb, you're not capable of doing that. You have to click the next button to see if it allows you to. I understand that we've now changed it from renting the property to advertising for the property, which underneath the city's code is the same bucket. So I understand the violation and the notice of violation would be the same. However, this is not done as a repeat violation, which is fine. I also don't find that there is a violation. So I'm going to dismiss this case. This has already been brought before me, especially with the evidence presented with the one review. So I am going to dismiss this case, and I will get you an order stating that, and I apologize. Well, I don't apologize for anything, but thank you for coming today.
No problem. Thank you.
Okay, moving on to case number 20260287, City of St. Pete Beach versus Cardinal Heights LLC.
Good morning, Special Magistrate Lucy Knight. Cardinal Heights, respondent Cardinal Heights LLC, violation address 1140 Bogaciga Isle Drive. Violation description, the property is in violation of section 46-33 subsection 3, enumeration section 9865 unsightly conditions. Subsection 4, the code of ordinance of the City of St. Pete Beach. Case summary, initial inspection 5/20/2026. Notice of violation dated and mailed certified 5/28/2026. Notice of hearing dated and posted on the property 6/12/2026. These pictures are a true and accurate representation of what I observed on the date they were taken. This is the affidavit of posting. This is the construction debris that was left on the driveway. It's an empty dumpster right next to it. They are now in compliance. They are now in compliance as of July 7th.
Jamie, back to the PowerPoint, please.
Property must be cleaned and all debris properly removed and disposed of. Property is now in compliance. Recommended fine was $250 per day from the date of your order plus 3/3 administrative costs and any recording fees that may be associated with this case. So we're just asking for administrative fees of 3/30.
Okay, thank you very much. Anyone here on behalf of Cardinal Heights LLC? Anyone here on behalf of Cardinal Heights LLC, 1140 Boca Ciega Isle Drive? Okay. All right, I am going to find that the property was in violation of the stated code section. The property is now in compliance as of July 7th, 2026. I'm not going to assess any fines, but I will assess the $330 in reasonable administrative costs of the city. All right, moving on to agenda item E, case number 20260107, City of St. Pete Beach versus Christopher H. Wilson.
Good morning, Special Magistrate Lucy Knight. Case number 20260107, respondent Christopher H. Wilson, violation address 228 43rd Avenue, violation description. The property is in violation of section 46-33 subsection 3, enumeration section 98-65 unsightly condition, subsection 1A, B, 3, Section 98-66, subsection 24, residential and commercial property maintenance of the Code of Ordinances of the City of St. Pete Beach. Case summary, initial inspection 2/23/2026. Notice of violation were dated and mailed certified. 3/18/2026, notice of hearing dated and posted on the property. 6/11/2026. These pictures are a true and accurate representation of what I observed on the date they were taken. Affidavit of posting. Fence is in disrepair to where it was all down on the ground. This is the opposite side, the east side of the property. And the construction debris up against the fence. Property must be maintained, repair, replace, or remove fence and remove debris. Property is now in compliance. We're asking for $330 administrative costs and any recording fees that may be associated with this case. Could you, this is the fence now, and I had permission, and he let me inside to take a picture with it. This concludes this presentation.
Okay, anyone here on behalf of Mr. Wilson? Anyone here on behalf of Mr. Christopher H. Wilson? 228 43rd Avenue. Okay, I'm going to find that the property was in violation of the stated code section, but to come into compliance as of July 7th, 2026. I'm not going to assess any fines, but I will assess the $330 in reasonable administrative costs of the city. Moving on to case number 20260168, City of St. Pete Beach versus Roma Invest Group, Florida, LLC.
Lucy Knight, case number 20260168, respondent Roma Invest Group, Florida, LLC, violation address 4151 Bell Vista Drive, violation description. The property is in violation of section 98-123.1, permits required, the Code of Ordinances of the City of St. Pete Beach. Case summary, initial inspection 3/30/2026, notice of violation dated and mailed certified 4/24/2026, notices of hearing dated and posted on the property 6/11/2026. These pictures are a true and accurate representation of what I observed on the date they were taken. This is affidavit of posting. This is where they was putting up the door on the day that I arrived there. And this is the old door that they put off to the side. This is the unpermitted door. Just a stop work order where I stopped them. Property must obtain a permit for work being done. Property is not compliant. Recommended fine is $250 per day from the date of your order plus $330 administrative costs and any recording fees that may be associated with this case.
Okay, and the violation is just for the replacement of the front door without a
Yes,
permit,
ma'am.
is that correct? Okay. Anyone here on behalf of the property owner, Roma Invest Group Florida LLC? Anyone here on behalf of Roma Invest Group Florida LLC, 4151 Bella Vista Drive? Have you had any contact with the property owner?
No, ma'am.
Okay. All right, I'm going to find that the property is in violation of the stated code section. I am going to allow 14 days to secure an after-the-fact permit for the installation of the front door. And that's 14 days from the date of my order. And if not, we will come back and I will assess any fines and fees that will be required.
Madam Special Magistrate Pete Dewar, Code Enforcement. When you say secure, could you please explain what that means?
The same as it has meant for the past couple of years, they need to obtain, they have to secure after-the-fact permit. So not just merely apply for it, they have to actually get it. Based on the testimony from Mr. Curtis at the last few hearings, doesn't seem like after-the-fact permits, especially for something so simple, should take very long. However, if it does, they can come back at the August 10th hearing and plead their case if they decide to show up.
Thank you.
Thank you so much, Mr. Dewar. Okay, thank you, Ms. Knight. Moving on to case number 2026-0315, City of St. Pete Beach versus U.S. Bank Trust National Association et al.
Morning, Special Magistrate Lucy Knight, case 2026-0315, respondent U.S. Bank Trust National Association, La Cabana Series 4 Trust, violation address 5903 Bimini Way North. Violation description, the property is in violation of section 46-33 enumeration, subsection 1A, B, 2, 3, 4, A, B, 8, 9, section 98-65 unsightly conditions, subsection 1, B, C, 2, 3, 4, section 9866 residential and commercial property maintenance, subsection 2, 7, 8, 9, 10, 14, 17, 18, 19, 20 of the Code of Ordinances of the City of St. Pete Beach. Initial inspection, 5/28/2026, violation of address, notice of violation dated and mailed, certified 6/9/2026. Notices of hearing dated and posted on the property 6/23/2026. These pictures are a true and accurate representation of what I observed on the date they were taken. This is the affidavit of posting. This is the light fixtures that's hanging down where the two red circles are. This is the stairwell where the arrow is pointing. They have tape holding it up. This is the cracked columns. More cracked columns. The palm fronds, debris on the ground. This is the rotten wood deck that is not safe. This is more the rotten deck steps going up to the deck. The boat lift that is rotted out and falling over. The damage to the seawall was a hole right where the arrow is pointing down in the ground, and it plus it's cracked. The exterior ceiling needs to be sealed or replaced. Back door peeling, and the wood is rotting on the door. The exterior crack on the wall. Entire structure must be properly repaired and maintained or demolished. Property is not compliant. Recommended fine is $250 per day from the date of your order plus $330 administrative costs and any recording fees that may be associated with this case. This concludes my presentation.
All right, and Ms. Knight, just for inquiry, some of those pictures were taken in the rear of the property, is that correct?
Yes.
Okay, and did you have consent from the property owner to go into the property?
Yes.
Okay. There are a couple of violations I see on here, well, just one of them, underneath section 46-33, subsection 8, it says, any building, structure, or other place or location where an activity which is in violation of local, state, or federal laws conducted, performed, or maintained. I didn't see any evidence that there was any illegal activity being conducted on the property.
Okay, I'm sorry about that.
That's okay, so I just wanted to make sure I find violation. You guys, you subsection them out, so I need
Yes.
to be very particular. Okay, so, and I didn't see any accumulation of stagnant water on the property. Did you see anything of that nature?
No, because the pool was covered.
Okay. And then for the abandoned and broken equipment, was that related to the boat lift that's out there?
Yes, ma'am.
And again, with the swimming pool violation, you said it was covered. Were you able to find out if there was any violation with regard to the swimming pool?
No, it was covered. We couldn't uncover it.
Okay. Okay, thank you very much. Anyone here on behalf of the property owner? Okay, if you could please come up and state your name for the record and affiliation with the property owner.
Yes, good morning, Madam Magistrate. My name is Joanny Fernandez on behalf of the respondent, and I come from Gadati Burger.
Okay.
Yes, Your Honor. So our client obtained the certificate of title. Right now, we just want to give you a status update. We did submit the permit on July 8th. We're just waiting on the City of St. Pete Department to approve the permit. Therefore, our contractor came in construction, can move quickly in making the repairs. It's not even a remediation. They're going to go ahead and demolish. All contractors are lined up. So we would just request an extension for the city to approve the permit to demolish the property, which we have spoken to the construction company, which would take about 7 days. And then we would just need time for the inspector to come and inspect the property, and if there's any other outstanding issues, for us to repair it.
Okay, and how long do you think, I know you said, what day was the permit submitted to the city?
July 8th.
July 8th, that's what you did say that, okay. And do you know where it is in the permitting process?
I am not aware.
Okay.
I'm not sure right now.
Okay. So it is the intention of the new owner to go ahead and demolish the property. What date did you take title of the property, or did your client take title of the property?
We took it on July 28th of last year.
Of 2025?
Correct.
Okay. Anything else you'd like me to know on this property?
Not at this time.
Anything else from the city? Okay. I am going to find that there is a violation of the stated code sections except for 43 subsections 8 and 9 and 98-66 subsection 18. But the remaining cited code sections, I will find that there is a violation. I will allow for, what is today's date is the 13th. I will allow, I've already applied for the demolition permit. I will allow 30 days from the date of my order. Well, let's do 45 days from the date of my order to come into compliance. That would be for the demolition of the property. We will set a status hearing for the September 14th code hearing to determination if the property is in compliance, if there's been a good faith effort moving forward, what's going on with the property, and I can assess any fines or fees if necessary at that time. So it will be 45 days from the date of my order to come into compliance.
Madam Special Magistrate, could you amend that, please, to next month's hearing for a status update? This property has been in violation since 2021. I know that's not before you, but we have an outstanding lien on this property, and it's been an eyesore in the neighborhood since 2021.
I don't see the value in adding a status hearing for when I've given a date of compliance of 45 days. Coming before the date of compliance wouldn't make any sense to me. Okay. But I would encourage the property owner to stay in contact not only with the city but with the code enforcement department to show that you are making good faith effort and moving forward.
Thank you.
But other than that, yeah, we'll see you back on September 14th if necessary.
Okay.
And then make sure I have your contact information on the team order to that effect.
Yes, okay, thank you so much.
Okay, and moving on to 4H, case number 20260134, City of St. Pete Beach versus Plaza Beach Motel LLC.
Morning, Special Magistrate. Officer Lucy Knight, case number 20260134, respondent Plaza Beach Motel LLC, violation address 46th Avenue, parcel number 063216000003301300. Violation description, the property is in violation of section 98-65 unsightly conditions, subsection 1AB4, section 46-33, enumeration, subsection 2 of the Code of Ordinances of the City of St. Pete Beach. Case summary, initial inspection, 3/6/2026, notice of violation dated and mailed certified, 4/20/2026, notices of hearing dated and posted on the property, 5/15/2026. These pictures are a true and accurate representation of what I observed on the date they were taken. This is the affidavit of posting, the construction debris, the pile of rocks, the poles laying on the ground. The property must be maintained and free of debris. Property is not compliant. Recommended fine is $250 per day from the date of your order, plus $330 administrative costs and any recording fees that may be associated with this case. I went out this morning and took pictures, and this is what it still looks like, but also they moved the trailer on the property now.
So it's the pile of rocks and dirt and then the wooden poles?
Yes, ma'am.
Okay. All right, anything else from the city?
No, ma'am, this concludes.
Anyone here on behalf of Plaza Beach Motel LLC? You'll please state your name for the record.
Your Honor, Robert Cezanne, owner of the property. Yes, that stuff is still on the property. It was on the property when I bought the property about 3 years ago now, and that is all city property stuff. Those poles are not my poles. They were actually by the city when the city was doing the Golf Boulevard improvement, and that was all the debris that they left there with the property. I refuse to take it away because it's taxpayer dollars. The taxpayers paid for that debris. The taxpayers paid for those poles. As soon as I remove it, I'm going to have residents showing up saying that Robert's stealing or recycling taxpayer stuff. So that's not mine. I told the city, I said, this is your property. You brought it here. You used it for construction debris. Take it away. I said, I don't want to touch it. That's the last thing I need. I already have enough targets on my back here in this city to be then saying that I'm taking taxpayer dollars away from the city. So I refuse to move it. The city has the machinery to do it. It's their equipment. Have them remove it.
Understood. Any response from the city on this?
Yes, ma'am. Pete Doerr, Code Enforcement Manager. I wrote Robert May 26th. To better understand your position regarding the materials on your property, can you clarify when authorization was granted for the city to store these items on site? Additionally, given that the materials are located on your property, you are ultimately responsible for their removal or disposal. And I mentioned that the case will be scheduled for hearing today. Mr. Cezanne's response was, city-owned materials remain on my property. The large light poles, pile of crushed concrete and or rock, and wheel stops are municipal materials associated with and resulting from the city-funded Golf Boulevard improvement project, which is what he just mentioned. But there was never an agreement provided to my email request.
Mr. Dewar, did the city have authorization to put the debris on Mr. Cezanne's property?
We don't know that for a fact.
Okay, but you are the city, so you have the ability to find out if your contractors and your employees put city debris on private property.
Agreed, but there is no
And you
proof
have-
that
well, you
we
have-
did that.
Right, but you have the burden to prove that there is a violation. I have credible testimony from Mr. Cezanne here today saying that that's not his property. And understanding your point
Yes.
that he is responsible for the violations on his property, and I don't disagree with you. I wholly agree with you. However, if the charging party is the one who is responsible for the violation on the property, and then now you are going back at him and saying, you have to clear the thing we did to your property, that becomes a problem. So on this one, it is the city's burden to prove now, because there's almost a rebuttable, not a rebuttable presumption, but now I have credible evidence stating that the city in fact caused this and is now trying to get somebody to remedy it. I have credible testimony saying that that's whose property it is. You're saying that we don't know if it's our property or not. Well, the burden now shifts to you to prove that it's not your property. So I understand your position. I understand Mr. Cezanne's position.
Madam Magistrate, may we ask for a continuance of this one, and that would allow the city additional time to see that if it is surplus property or if they've relinquished any type of ownership interest in the property?
I agree, and even if there is a relinquishment in the property, I would also suggest that if there has been a relinquishment, I would like to see that, because I am in a position right now where I have one party saying you are violating, and the other party saying I am violating because your stuff's on my property, and now you're trying to charge me, a private citizen, to clean up city things, and with a concern that says, and if I do it, which I might be willing to do it, but if I do it, now I'm going to get backlash for some sort of theft or misuse of public property. So yes, I'm willing to grant a continuance until August 11th for the city to figure that out, and I would just encourage the parties to work together to figure out how that got there, when it got there, and if the city needs to remove it, because Mr. Cezanne says it's not his.
It's okay.
So I will grant a continuance until August 10th at 10 a.m. Understanding that the next one, 4I, is actually a repeat violation, which will be underneath 5. I'm going to call it because Mr. Cezanne is here. So 20260104, City of St. Pete Beach versus Plaza Beach Motel, LLC.
Madam Special Magistrate Pete Dewar, Code Enforcement, are we able to consolidate the next two cases, the two repeats, please, like you've done previously?
Okay, yeah, and so I will also call case number 20260201, City of St. Pete Beach versus
Jamie,
Plaza
go
Beach
to the
Motel,
overhead,
LLC.
please.
Before I do so, I want to make sure that's okay with Mr. Cezanne. I do recall these cases being consolidated for the underlying violations. Yeah, okay. I will go ahead and consolidate those two cases. The evidence will be presented in one, and it will be one hearing. The violations will be treated separately within my order.
Madam Special Magistrate, the overhead shows your order. Paragraph 4 shows the violation sections. Would you like me to state those for the record?
It's up to you. It's your case.
Yes.
Section 1.3, 3.5, 4.8, 23.4, 23.7, 23.11, and 38.4 of the Land Development Code, and section, that's not included. Moving on. So this property is being used for storage as well as parking. The respondent is using the vacant lots on the property for off-premise parking for its business without having a conditional use permit as required by the Land Development Code. You assess the respondent $50 per day for this specific case, which we're bringing back as a repeat violation. And we would like the imposition of $500 per day fines from the dates these pictures were taken. These pictures, I can have the officers that took the pictures to attest to their accuracy.
Pete, for the record, can we go ahead and do that?
Yes, please.
Yeah, I was going to ask, can we present the cases, not just the fines that are being requested? It is a repeat violation, but the evidence is necessary to secure that there's a repeat violation.
Your Honor, I believe we also have a witness testimony that we would like to put into the record as well.
Okay, can we please start with the presentation of the evidence, and then we'll call the witness after the presentation of the evidence?
So this first picture is taken by Officer Newman, who is going to attest to the accuracy of what he observed on the date it was taken.
And Officer Newman, have you been sworn in?
Yes, ma'am.
Okay, thank you.
Yes, I took these pictures on the date, I guess it was 4/18/26. At the time, there was a young lady there, and I asked her if why they were parking in that lot resulted from a complaint. She said it was for a celebration of life. I asked her if she was charging, and she said no, and I found no evidence of that at the time.
Okay. And this is all from a single day?
Yes, ma'am.
Okay. Okay, and what am I looking at here?
Pictures that were taken just of the lot.
This picture was taken by Officer Jones, and he can attest to the accuracy of it, please.
And Officer Jones, have you been sworn in?
Yes.
Thank you.
So these pictures are true and accurate representation of what I observed on the date that's there, which is May 24th.
Okay, so it looks like there's an SUV, a truck, well, a Jeep truck, and then there's somebody mowing the lawn, is that correct?
Yes, ma'am.
Did you have an interaction with anyone while you were there?
Maybe I just seen there.
Ms. Knight, okay.
Yeah, I spoke to the gentleman here, and he allowed me to take the pictures, and that was it. I was just there to take the pictures.
Okay, you didn't interact with anybody on the property?
Just this gentleman here.
Just Mr. Cezanne? Okay, and what were your interactions with him?
Well, I was taking pictures, and he allowed me well, he just allowed me to take the pictures. So I told him I was there to take the pictures. He allowed me to continue to do that. That was pretty much it.
Okay, but we don't know why the cars were there, whose cars they are?
And no,
Okay. And do you know how long the cars were there for?
I do not. They were there when I arrived.
Okay, great, thank you.
Thank you. Officer Knight, these other pictures. These pictures prove that there were storage as well as in the property. And Officer Knight can attest to the accuracy of these pictures.
Lucy Knight. This is the picture I took on July 10th of storage units that was sitting there in the miscellaneous debris. This is these pictures are true and accurate representation of what I observed on the date that they was taken. This is a better picture of what the containers look like. I went this morning, and this is what it look like now. You can just see the trailers that was parked behind the storage units and the miscellaneous debris that's on the side.
So, Madam Special Magistrate, from April 18, 2026, through today's date, we are asking for a repeat violation on this property.
All right, any other evidence that you'd like to submit?
This concludes our presentation
The
at this
witness?
time. As a matter of fact, we have a witness who would like to testify to a picture she took with a sign that says beach parking.
Call your witness.
Amy Arbach, please.
I came in late, so I wasn't sworn.
Okay, if you could state your name for the record.
Amy Auerbach. I live on 46th Avenue.
Okay, and how do you spell your last name, Ms. Auerbach?
Auerbach.
Okay, and if you could raise your right hand. Do you swear from the testimony you're about to give the truth, the whole truth, and nothing but the truth?
I do.
So sworn. Okay, and what testimony do you have today, Ms. Auerbach?
I have testimony that I took this picture on Saturday, May 23rd, which was the Memorial Day weekend, where beach parking was being advertised on the corner of where the Yakamono is, at the corner of 46th and Gulf Boulevard. And cars were just going in there to park all of Memorial Day weekend. But this is specifically the promotion for that on May 23rd.
Do you have any photographs of the actual property at issue here with any vehicles being parked on it?
Yes, I shared them with Nancy and Pete. They just didn't print them out, I guess.
Okay.
Do you want me to bring them up on my phone?
This is the city's
Yes,
case, so.
yes, we need to put those into evidence.
Okay.
Okay. All right, so this is May 23rd, 4:55. Here's a video along the south side fence line on that day. May 23rd. Let me get the point.
I do, thank you.
There's also promotion on both sides.
Anything else, Ms. Auerbach?
That's it.
All right, thank you.
Thank you.
Anything else further from the city?
No, ma'am.
Okay, I do have a question. The order that has been provided in the evidence packet, unless there's another one, is dated December 13th, 2023. And that order is specific only to violation for a fence permit and states that the parking is not an issue and that has been complied with. Is this the order that the city is wishing to present for the underlying violation that this property cannot be used for parking or storage?
Yes.
I would have to defer to Mr. Dwar. My understanding was that there was a violation for parking, however, it came into compliance, and this is a subsequent violation for parking, but please correct me.
And if that is the case, I'd like to see the underlying order with regard to that. And the only reason I ask is I know that myself and Mr. Thanis both heard evidence with regards to this case, but the order that's provided does not deal with parking.
question, please?
My question was, for these two cases, the evidence that I have presented in the packet and that has been shown today has an underlying order dated December 13th, 2023 for the premise that these violations are repeat violations. However, that order only states that respondent was in violation of the magistrate's order with regard to the fence permit, and that the testimony that was brought states that the parking was not in violation and had come into compliance. So based on this underlying order, this would not be a repeat violation, as the underlying order does not deal with parking violation. It deals with the erection of a 6-foot fence.
If I may ask the question, we do have the order, do we not?
Yes, I'm looking at it.
Okay.
And so I'm trying to see what was ordered.
And I recall this case, but
No, we
bringing
want
a repeat violation, I need to know what the order is with regards to the underlying violation, and if there was actually an order that stated that there was an underlying violation, or if there wasn't. I need that there was a finding of the off-premises parking. I remember Ms. Cole coming in and arguing that there was a conditional use permit that was being applied for. I have vague recollection, but that's not helpful. And maybe while the city is looking that up, perhaps Mr. Cezanne could go ahead and he can testify to his portion of. All right, Mr. Dewar, while you're looking that up, I'm going to go ahead and, is there anything further from the city on this, aside from my inquiry with regard to the underlying order?
Not at this time. We're going to allow Mr. Cezanne to testify.
Yes, I am going to allow Mr. Cezanne to testify. Mr. Cezanne, if you'll please come up here, respond to the city's violations against you.
So I want to get a better understanding of why I am here. It's two different things. So is it the containers and is it the parking? Is that why I am here, for those two reasons?
Yes.
Yes, okay, perfect. All right, so let me address both reasons for you. And Madam Magistrate, you're absolutely correct. Last time I was here, it was actually for a fence. There was no parking, so this is not a repeat fence. It was an understanding that I would not park cars there, but there was never a violation. So I have not been parking cars there, with the exception of those two times that were both shown. The first one, as the person testified, was for a celebration of life. It was a dear friend of ours on St. Pete Beach who lived in Bella Vista, been a resident his entire life, passed away, and we did a celebration for life at the hotel for him. And we needed parking, so I made an executive decision that for this one event, we would open up the facility and do that for the celebration of life. So that was a one-day event. The second time we opened up the parking lot was for Memorial Day weekend, and we rented the parking lot out for Saturday, Sunday, and Monday. So there was 3 days of cars there, and that was basically a help to the city. The city is in need of parking, and I did the right thing by trying to help the residents as well. The residents constantly complain about the cars being parked up and down the beaches, and people can't find any parking spots. So I decided to make an executive decision, open up the parking lot, and honestly saved hundreds and hundreds of cars from being towed from the Dolphin Village shopping centers, where they get towed from all the time. So being in the business I'm at, I'm in the tourism business. Tourists only come back to destinations where they want to come back to. And unfortunately, the city doesn't realize that they are biting off the hand that feeds them. The only reason the city has a job is because people like me that bring tourists to this area. So it's the tourism that comes back. No one's going to come back to our area next year if their car got towed this year. So if their car got towed, we literally saved hundreds of cars from being towed. They were all thanking me because there's so many people. Nobody ever comes back. Next Memorial Day weekend in 2027, they would never come back to St. Pete Beach. Hopefully by then St. Pete will have more parking. But I literally did a public service job that weekend and saved people's cars from being towed. Then I donated all that money as well to charity with my kids. So I could have been anywhere. I don't have to rent parking. I own 3 planes. I could be in the Bahamas. My kids could be with me. We literally did that to show my kids work ethic and giving back. So my kids were there. So the people holding the sign, that was one of my daughters. So my daughter was there, my son was there, and we had another one of my son's friends helping out. So we did it because we did the kindness limit, and we did it for the city. The city doesn't realize they did it, but we did it for them. But we did it for the city, and we did it for the residents as well that had no cars down their streets, and they complained about all the cars down their streets. So that's what it was done for.
Okay, and the containers?
Containers are, because I am one of the largest privately owned owners of land on St. Pete Beach. I own property up and down. I don't know if anyone else owns as much property as I do. That's all from the hurricane recovery. So all those containers have hurricane recovery stuff. We've now moved them. So, but the containers got there as soon as the hurricane happened. The first thing when the hurricane hit, I immediately got 2 containers on there. Then the 2 containers became 5 containers. I own 3 hotels, I own the Dunkin' Donuts, I own real estate all over the beach. And all that stuff was hurricane recovery. And what's unfair, and why I'm being targeted, is because I'm Robert Cezanne. Everybody else has containers and still recovering from the hurricane. I asked the city, I'm like, why can't I still keep these containers here? They said, the hurricane recovery's over. I'm like, really? The hurricane recovery's over? I said, look around. How many people still have containers? How many people are still working on their houses? So they still have time to work on their homes. Yet, I don't have the privilege of working. Luckily, I moved all the containers. I had to move them off-site to another location, so they're no longer there. But I personally feel targeted. My attorney feels I'm targeted as well. There's no question about that. But we did comply. We did move the containers. So as of Friday or Saturday, they were all moved out. So the containers are there. There's still a little bit of debris there, which we will clean up. It's just going to take us a week or so just kind of find homes for all that stuff. But the containers are moved. I'm not happy about it. I personally feel I'm being targeted by the city, but the containers are moved.
Okay, thank you, Mr. Cezanne. Anything further from the city?
No, Your Honor. We were still in the process of looking for that order, and I think that Mr. Dewar, I think he agrees that maybe we do a continuance of this case.
Yes.
To straighten it out. Having heard the testimony, that's very helpful.
Mr. Cezanne, do you have any objection to the continuance?
I do. Yeah, this is a waste of my time. It's a waste of your time as magistrate. It's a waste of, this is just ridiculous. There's no reason to continue this case. There's no violation here. Yes, did I park for those 3 days for Memorial Day weekend, that one day for 4 days? Yes, I did. And I told you why I did. And if you want to find me, go ahead and find me. But this is done. Let's get it over.
Okay, I do have copies of the orders.
Madam Special Magistrate?
Mm-hmm.
As I just heard you say you're looking at the orders, respondent was notified that, and this is paragraph 4, as I mentioned in my testimony, respondent was notified that it was respondent was notified that it was in violation of sections 1.3, 3.5, 4.8, 23.4, 23.7, 23.11, and
Correct.
38.4,
That
which
they
are
received
all
a notice.
parking.
Right, but they received a notice of violation on those, that they noticed that they were violated. That's not underneath the conclusions of law and the order section of the order. That's underneath the findings of fact portion.
Correct. And in the order, paragraph 8,
That, I
respondent
see.
brings the property into full compliance with applicable
But number
city
7 says respondent failed to comply with the terms of the magistrate's order dated November 16th, as the fence permit had not yet been secured.
Right.
Nothing in this order says that there is a violation of any parking ordinance. This order, it's my order, so I'm
Yeah, right.
well aware of what it says, that says that they were notified that they were in violation of those code sections, not that they were in violation. That was what the notices of violation said. So I need an order that says that they were in violation of those code sections from a special magistrate. The city has not provided that here today.
Okay.
So if the city would like to recite Mr. Cezanne underneath a non-repeat violation section, I'm fine with that. However, based on the evidence that's been presented here today, and the objection from Mr. Cezanne with regard to the continuance, I'm going to have to find, based solely on the information that was provided here today, that this is not a repeat violation. And so no fines will be assessed, no administrative costs will be assessed, and I will get an order finding that there is no repeat violation of the stated code sections.
Thank you.
Thank you.
Now, Mr. Cezanne has admitted that there was a violation of the code. However, that's already been tied to this notice of violation. So I just want to tell the city that you cannot use that evidence in the future for a future violation. It will have to be a new evidence for a new violation. That will be for both of those code cases. So, Mr. Cezanne, I have your information, so I will get you all an order stating that there's no violation on case 2026-0104 or 2026-0201, as these are both noticed as repeat violation, and there's not sufficient underlying evidence to show that there was an initial violation of those code sections. Okay, moving on to subsection 8, lien reductions, case number 2025-0189, City of St. Pete Beach versus Marilyn L. Nolan for the Marilyn L. Nolan Revocable Trust.
Good afternoon, Madam Magistrate. Stephen Rivera, City of St. Pete Beach Code Enforcement. This is a lien reduction for case number 2025-0189. This property came into, let's see here, August 18th. The property was found to be in violation. There's a copy of the order. 4633, 9864, 65, and 66. I gave the respondent 60 days to come into compliance. And $250 a day from July 16th, 2025. Bear with me, this is my first time doing a lien reduction.
No worries.
Trying to make sure you get all the paperwork. Here's the lien reduction application from the property owner. Property owner information. The total lien amount currently is $23,611.75. Not sure what the respondent is looking to have it reduced to. The property is now compliant. The buildings have been demoed.
Okay, it looks like the argument or the basis for the lien reduction is that the notices were not received, though they were sent to the property address that was located on the tax collector's website.
Correct. And that's been updated. I still have the old one showing that it was going to Springfield, Missouri.
Right.
All our paperwork's been filled out.
Okay, so the property is in compliance now?
Property's in compliance. However, the city stands on the full amount to be collected. However, we'll let Ms. Nolan speak on her behalf.
Absolutely. Okay, and for the respondent, if you could please state your name for the record.
Good morning.
Good morning.
I'm Marilyn Nolan.
Good morning, Ms. Nolan. And can you let me know what the basis for your request is?
The main reason, and he's already said, I was totally unaware of the proceeding. Had I known, I would have taken care of it immediately. I did provide an additional addendum last week where I gave a little bit more detail. After the storm, I didn't know exactly how to proceed. I did try to contact Luke, the gentleman that condemned the buildings. I made numerous phone contacts. I did, and each time I would say, I live in Gulfport now. I had transitioned from Missouri to Gulfport full-time, end of 19, beginning of 20. So I had paid the taxes on the property from a bank in St. Pete Beach and from my address in Gulfport. So I assumed, as far as any legal notification, it would be based on the taxes on the property were paid from the address in Gulfport. I was unaware that they totally unaware that they were being sent to Missouri, but because of the length of time that transpired, I was no longer getting any forwarded mail. So I was just totally unaware. After the first of the year following the storm, I would call Luke's office. I did get one email saying to apply for permits. I wasn't sure because I had questions. The 2 buildings in back were condemned. The front building, which was historic, I didn't know if we were going to try to save it. I needed to spend more time trying to decide what to do with that property. But I did make repeated phone calls, and he did have my email address, and he did have my phone number in Gulfport. Then after the... Oh, and I never did get a phone call back. I did get the one email saying to apply for permits. As everybody that I knew that was applying for permits, nobody was getting them. My renters that I had all were able to find other property. I actually helped them move, and what they could salvage, I helped them put stuff away and get into storage. So because I wasn't sure what I wanted to do with the property, I figured I would just go to the back of the line and take care of it as I could. After the first year, I was in a car accident and was hospitalized. I've had 3 eye surgeries. I have another one coming. I can barely see you today. This is my driver. So had I been aware of this, I would have taken care of it immediately. I would not have let it gone on.
Okay. And so to Mr. Rivera's point, the application for lien reduction doesn't give what you're seeking to have the lien reduced to. Do you have a proposed amount to seek the lien reduction for? And I would like to preface that with, this process is remedial after the fact. So the city did follow the law and got the notices to the appropriate place. And I do sit in a position of equity, so I have to follow the law, but I also have a little wiggle room in being able to take into other things into consideration that are not straight legal. That being said, there were proceedings that happened. I did assess fines with it. Those fines did accrue into the $23,000 lien. So I'll just be frank with you, I'm not going to reduce it to 0 because time and money was spent doing this and the city didn't do anything.
And I realized the city had expenses.
Right.
Yeah.
So with that being said, what is a proposed amount that you would like to see the lien reduced to, if you have one?
It's a 0 and I'd like the chance to speak. May I speak on?
Yeah, if you can state your name, yes.
Harry James Assenheimer Jr. I was duly sworn in. I find myself wearing many hats. I'm a friend of Marilyn. I've known her going on maybe 15 years. I've also been a realtor out here for 30 years on this beach, and I've been privileged to be Marilyn's realtor for 5 transactions now. And I own approximately a block of property within 2 blocks of the subject property. And so I've been dispatched on numerous occasions to be the person walking the property with the city and identifying notices on doors that was news to Marilyn. When I had Craig Green from the city come out to my properties, very congenial gentleman, spent hours with us. I know more about Mr. Green and his past and his weight and everything else. Very civil person in the overwhelmingness of what everybody was going through. I asked him if he would walk my friend's property with me. We went down, we looked at it. I said, the condemned stickers. He said, yeah, we ran out of temporarily unsafe. I said, gee, that sends a different message when you post temporarily unsafe than condemned. So would you mind walking through the big structure with me? Walk through the 1920 structure. He looks at me, he says, this is toast. No one's spending money on it. It's not worth it. I said, it's historic. It's 1920. Maybe the city would like it up at the shuffleboard court. Maryland offers it for $1. At the same time, we were dealing with Mr. Rivera because I had received 4 notices for my 3 properties for vegetation that was unsightly. That was what originally got us to focus on Maryland's property. Went down there and found the condemned stickers. And that's when we started to respect Mr. Green's advice to contact a demo company. It sent Marilyn a bunch of companies. She picked one. They called up. They said, yeah, we can't tear them down. I said, why? The Historic Society says you can't tear them down. I said, well, one door at City Hall is telling them to tear it down. The other door at City Hall is telling them not to tear it down. And at the same time, she's being fined for not complying. This seems silly. So when you call up the city, I can't tell you how many times I've tried to reach Luke. He's the wrong person for the job. When he finally showed up at my property about a month ago and told me he has 7,000 cases and get in line, it's not really the attitude you want to have to hear after 2 years of waiting. So, to me, the way the city has handled this has been worse than the storm. The storm was 6 hours of nightmare. The city's been nearly 2 years of nightmare. You've created the need to comply versus just being impacted by a storm and dealing with it. When I called a couple of weeks ago to address this matter, I tried to explain to the woman that answered the phone that a client had been directed to do something by the city, but then told she couldn't do something by the city. She looked at her notes and she said, it looks like we've done everything by the book. And I said, how can you say that when one of your own reps told me he put condemned stickers instead of temporarily unsafe stickers because he ran out of them? And her response, I'm not making this up, was, oh, that's a different department. I called up with a complaint that 2 different departments were saying 2 different things. And I got the same exact response from that. Let me tell you, on the overwhelming nature of already been pounded by these storms, to continue to suffer at the plight of the overwhelming tasks that you folks are surfaced with has been a challenge. We got a dock down on 7th Avenue in Pasadena. Still can't walk on it.
All right, Mr. James, I appreciate this. If you want, no, sir.
And I'd just like to finish.
Mr. James, this is my hearing. I don't work for the city of St. Pete Beach. I don't work for the citizens of this community directly, but I do as an independent special magistrate. Part of that is public dollars go to pay my time to be here, so we need to be judicious about that. The thing that is before me is a lien reduction for Maryland's property. And I'm happy to let you speak if you are going to speak to the little question that I asked, which was, what are you looking for the lien to be reduced to? Your comments are valuable. I think your comments would be better suited going to the city commission, which is the legislative body that controls the governing of this city. And then I can do nothing for you here today. The folks in this building can do nothing for you here today about what you're discussing.
I was just given that as some background for why I'm coming to my answer with regard to the dollar value.
And I appreciate that, but other properties in this community are not going to impact me on how I can reduce the lien on this property.
That I made over the last 2 hours, I'd just like to finish my points with respect. The timeliness of Maryland's compliance has been affected by the 2-door city hall. One door says do it, the other door says you can't. She didn't have any written notice of an amount. And Mr. Rivera was explaining to that over the vegetation matters, not even the condemnation matters.
B0, so Ms. Nolan, what is it? Mr. James, B0, so Ms. Nolan, what is it? Mr. James, I appreciate your...
Thank you for your time.
I appreciate that.
I'm going to sit down and get out of your way.
Ms. Nolan, what I've already said, I prefaced that with, I'm not reducing it to 0. So what do you think would be a fair amount to reduce it to? What are you requesting? This is your petition.
Yes, I know the city has cost and expenses associated with this, and I value your time. I value all of your time. So I don't have a lot of money sitting around. I'll just be real honest with that because I lost all the income from there when I lost the buildings. But 3,000, 5,000, whatever.
Okay. Thank you, Ms. Nolan. I appreciate that. Anything further from the city on this one?
No, ma'am.
And Mr. Rivera, the $23,611.75, is that inclusive of the city's administrative costs?
That's the administrative costs and the lien recording fee.
Okay. Can you
total costs?
What is the fine? Just the fine amount on that?
It would be minus the, I don't have the numbers in front of me, but it'd be minus the $330 and then $18.50 for the lien recording fee.
$18.50, and then the $330 in admin. Okay, so.
And I apologize, I didn't have those numbers in front.
That's okay. I didn't have the request in my packet, so 1850 minus 330. Okay, so by my calculations, using a calculator so that everybody's on the same page, I have the total fine amount is $23,263.25. And I'm going to reduce that to 10% of that amount, which is $2,000, $2,326.32, plus the $330 in administrative costs of the city, plus the $18.50 for the recording fee. Ms. Nolan, I appreciate your time here today. I understand the complications. I understand that the city didn't do anything wrong. They followed the book. They are a legal entity. They are made of people. The people are doing the jobs that they are given. So this is just a confluence. This is why the city has this type of a process in it so that you could come back before me. I cannot do anything about the violation on the property. It is what it is. But I will get you an order. Please make sure I have your current contact information, email address, or mailing address so I can send the order to you. You will have 30 days in which to pay it. If you do not pay it within 30 days, then it will revert back to the full amount that the lien was calculated for. Anything else from either party here today?
No, Madam Magistrate, just for the record, what was the amount again?
So you told me that the lien amount with the costs and the admin was $23,611.75. I subtracted out the $330 and the $18.50 from it, which ended up being $23,263.25. And then I took it down to 10%, which is $2,326.32, plus the $330 in admin costs, plus the $18.50 for recording fees.
Thank you, ma'am.
You're very welcome. All right, thank you very much, Ms. Nolan. I appreciate your time here today.
I appreciate it.
I don't have anything else on the agenda, so the next meeting is scheduled for August 10th, 2026. Anything else from the city that we need to discuss? Do we have one more case?
Yes, ma'am.
Did I skip it somehow?
It's letter B for the lien reduction in Section 8.
I don't have on my agenda, which I printed, I don't have a second lien reduction. I don't have a second lien reduction on this agenda that was provided to me this morning.
This is the
It's not on the agenda. It doesn't need to be agendized as long as all the parties are here.
Oh,
so
yes,
I don't
he's
have a
here.
Okay.
You issued an order. You are correct, ma'am.
I'm sorry?
It's not on the agenda. You are correct. You
Okay.
issued an order.
When did I issue an order?
Do you have a copy of it for the magistrate?
My question is, I don't have anything else on the agenda, and it wasn't brought up during changes to the agenda that there was an additional item added under lien reduction. I will hear it today if all parties are here. I don't have a problem with that. Nothing is required to be agendized. I just need to know the information so that I can consider it.
Yes, ma'am. Lucy
Give me the
Knight
case number.
is 2026-0046.
Okay, and the property address?
3593 Bell Vista Drive East, St. Pete Beach, 33706. Respondent Robert E. Pardo.
Mr. Pardo, okay. Actually, interestingly enough, I think on your online agenda, there might be one. No. Anyways, okay, please proceed.
So the fine and lien amount is $2,800. Administrative fee is $330. Total fine and lien is $3130. It's consistent with our policy, so the city does not recommend a reduction.
Do you have a copy of the reduction application? Can you put that on the other side?
I was able to pull it up off
You
the
found
city's
it?
website.
Okay.
Oh, I have it in my hand.
Yeah, if you could please go ahead and just at least put it on for the record.
The lien reduction application request. Mr. Robert Pardo, 3593 Bell Vista Drive. This is the parcel ID 073216075420040190. This is primary residence. The date of the fine or lien imposed was 6/8/2026. The lien amount was $2,800. Administrative fee is $330. Total fine and lien amount is $3130. He is requesting it to be reduced to $870 plus $330 admin fees. notarized and signed by Mr. Pardo. And this is his tax collector.
All right, and Ms. Knight, you said the city stance is they're not agreeing to any reduction.
Yes, ma'am.
Thank you very much. Mr. Pardo? Please explain to me your reasons for the request for the reduction.
Yes, good morning. Thank you. I'll try not to be long-winded because I know you didn't have this on the agenda, so I'll try to be very brief and not long-winded. But thanks very much for having me here. I'll see what I can do in providing you the basis of what the reduction is. I'll try to touch on a few items.
And I'm going to just preface this with Mr. Pardo because you were here a couple of times defending yourself with regard to the violation. If it has anything to do with anything you've mentioned previously in defending the violations, I am not going to take that into consideration for today's purposes because I've already taken it into consideration in assessing the original fines and the lien amount.
Yeah, there is some new information I'd like to go ahead and share with you all.
I would appreciate it if
Thank
you
you very
could
much.
contain your comments.
You bet, you bet. And I just wanted to go ahead and open up and say, you know, that I was quite shocked when you had asked me, and I guess we met on a month ago, and when I heard the outcome, I was surprised, and you had asked me, is there anything more you'd like to add? And at the time, I was just at a loss for words. So I've gone back and I've reviewed some items, and there are essentially 4 areas that I'd like to just touch on. Again, I'll be brief. And as I reviewed the photos, I'm going to suggest that there's a discrepancy of the violations. I also wanted to go over a second item regarding the communication that I had with the city and code enforcement, and me not having the appearance here on May 11th. And lastly, the expectations of homeowners. So I convey all this with great respect, and whatever the outcome may be, I will honor that. But I just wanted to share this, not so much to benefit me or to have something that's justifiable, but I think across the board for the other residents of St. Pete Beach. I heard Mr. Cezanne say a little while ago that he was advised that the hurricane recovery is over, and that's unfortunate to hear. And I also heard testimony about the communication, and I think that's something that needs to be enhanced for the city to operate in that manner. So I'll continue. Please jump in at any point in time.
I would just say anything in the discrepancy regarding the conflicts of the violation, I'm not going to entertain any of that today. Because that should have been done during the time period. You were back here several times, so that should have been raised at those times.
Well, I was here a month ago, and I was here 2 months ago. So this is my 3rd appearance.
Correct.
So with regard to an appeal, and again, I'm naive about this in the process, but when one enters into appeal, aren't they able to?
It's not an appeal.
Oh, it isn't?
No.
Well, then what is the?
You have requested a reduction in the lien amount, not an appeal of your underlying violation. That is a separate process, and I am not here to hear appeals.
Oh, okay.
I cannot hear appeals.
Okay. Well, then my approach with the city was inaccurate as well, because that's what I was suggested it would be. Well, then I'll bypass that. That's unfortunate, but I will summarize that I did go through the 3 sections of the violations, and it does specify height in increase, a height in excess of 10 inches and 12 inches. I don't see anything in those photos where anything was in excess or near 7 inches. Want to suggest that. Also, with regard to trash and things of that nature in the yard, nothing there.
I know. Mr. Pardo, I have said I don't want to hear anything on that. You can continue down that road, and I will cut off these proceedings and decline your lien reduction.
I'm
This is unlike a violation proceeding.
Okay. All right.
This is a reduction in the lien where you give me, underneath the specified code section, any information as to why you think the lien should be reduced that does not have to do with your previous arguments on the underlying violation.
Very
You
good.
waived those arguments for purposes of this proceeding. They should have been raised in the underlying.
Very good. Well, then I'll go ahead and just go to, I just scanned through these pages. That's what was covering. I'll go ahead and go to the next area with regard to the communication. So I have communications here with the city.
Are these after the orders were issued?
No, ma'am. They were for specifications or clarification regarding the violations.
Okay, Those should have been raised during, I don't want to hear anything.
Then I'll skip over that too.
To the actual violations. All I want to hear from you is why your lien should be reduced, not why you shouldn't have been found in violation.
Well, then I'll skip through a lot.
Thank you.
And I say that, again, with respect. I know time is precious. I will say this then. I'll put all this aside. And thank you for bearing with me.
Of course. This can be a difficult process to go through, and I understand that this distinctions are nuanced a little bit. So.
Oh, yes, and I appreciate that very, very much. Can I use this overhead then? Is it? Okay. And if this goes in a direction you don't want,
I will
please.
let you know, don't you worry.
Well, good, all right, thank you. This is it upside down for you, or can you see that?
Sideways.
Thank you very much. Officer Knight. Just want to show you what it looked like after the storm.
Yes.
And the
I'm
way
not going to entertain this.
Oh, all right, well then that's gone. Been a lot of work done at the house.
No, I understand. And Mr. Pardo, I understood that before.
Okay.
And keep in mind, after the storms, you did not receive an immediate violation. I have already heard all that testimony. I have already considered everything with regard to your tree contractor coming out, everything that happened. I understand that.
Thank you.
That has been heard, and that is why I assessed the fines that I did and gave the time that I did. I took all that into consideration.
Very good. Thank you.
That said and done.
Okay.
The only thing you're asking here is to reduce that lien amount, and I need to know why you're looking to have that lien reduction.
I'll try to be more specific to that, okay. I want to suggest to the city and special magistrate that this is a two-way street. You know, I see through the city of St. Pete Beach. I've been here for a long, long time. And I've done a lot on my part to try and assist in any way I can the city and the other homeowners that have gone through this. Oh, thank you very much. This is where I used to drop that kayak of mine. It's still closed since the storm. And that's in the park in our neighborhood in Bella Vista. This is the kind of condition that we have with traffic in Bella Vista. And these are all within the last 2 weeks. This is the condition.
Your Honor, I object because this does not get to the heart of his specific case. If these are adverse conditions, they're going to impact every resident.
I don't disagree, Ms. Dubridge. This is also not a legal formal proceeding with introductory of evidence. There's no evidentiary standard. This is an administrative proceeding.
Okay.
Which you are asking to reduce your lien. I have not heard anything, nor will I entertain anything else that has to do with the conditions of the code violation. I have a very specific question, Mr. Pardo.
Yes,
Why
ma'am.
are you asking for the lien to be reduced? It is a money situation.
It is a money
The
situation.
money has been assessed. You have a lien. You are in compliance. I understand your neighborhood. I understand recovery from the hurricane. Why are you asking for the lien to be reduced from $2,800 to $870?
I was seeking something that's more justifiable. If I haven't done my part and I've done everything that I can, it's progressed. It's gone real, really good. I know that these fees weren't an intention for any form of punishment. It's for the safety and beautification. And the home has come a long, long way. But with that also said, that, you know, there are expectations of homeowners, and, you know, we have expectations of the city. So Paso Grill, you know, that's still in an area that's disarray. Here at Sunset Park, disarray. And there are areas of sidewalks that have just completely collapsed where there should be some cones there for citizens' protection. So the reason for that, Madam Magistrate, is that, you know, if I'm due to go ahead and pay some fines, I want it to be comparable to what the city's going through. They're going through, you know, budgets and monies and workers that won't even show up. So that was the basis for it all. That, you know, for what the condition of that property is in, I think it's come a long, long way as of a couple of months ago. I still have an open permit. I'm now in, you know, we're in a new hurricane season. I need to get this thing closed. I still haven't passed inspections. And that's the communication I've had with the city. So I'm trying to address your question, the basis for it. I'm just looking for something more justifiable. And what I tried to base it on was $30 a day for that time frame plus the administration fees.
Okay. Thank you, Mr. Pardo. I appreciate you coming to the head of it.
And it's been a learning experience. I mean, it's made me, I think, a better individual, at least from a better homeowner, and I know the laws a little bit better, the codes, which is something that I should have known years ago, being here a long-time resident.
All right, thank you, Mr. Pardo. I appreciate that. Anything else from the city?
No, ma'am.
Okay. Mr. Pardo, your reason for looking for the reduction was justifiability based on a comparison between as a homeowner and what the city is having to do, what the city should have to do, what you should have to do. I am not going to grant the reduction request, and this is why. I took into account your position. My position here is irrelevant of what the city is doing. I'm going to tell you what I told Mr. Perry before. If you have a problem with what the city is doing, there are legislators that you elect that sit at this dais that you can go to and tell them that. I am not here for that. I am here to listen to you, which I did at several hearings in the past, to make sure that whatever fine I assess, if I assess a fine, and whatever fees that I assess are reasonable based on the circumstances. I did that. I took that all into consideration when I was assessing the fines on your property. I listened to the things that you had to say. We granted continuances. I took all that into consideration because I can. I'm also confined by the law because that is what everyone that purchases property is confined by, right? So all that to say, I did all of that. I didn't hear anything here today that I didn't already take into consideration, except that I should have to pay less because the city should be doing more. That has nothing to do with your code enforcement case, and that has nothing to do with a reason why you should be looking for a reduction in lien from my perspective. So I'm not going to be reducing it. It is going to stay at the 28,000 or 28,000. I did not up it. Sorry about that.
It's not recorded.
For the fine amount plus the $330 in administrative fees. And I'm going to get you an order that states that. I do appreciate you coming here today. I've appreciated your appearance every step of the way. You've done more than a lot of people have, but I just don't find that the reasons are justified to reduce the lien.
All right.
Thank you very much for that, and I have your information. I'll get you an order on that as well.
Very good. Thank you very much again, okay?
Thank you, Mr. Pardo. Is there anything else that is not on the agenda that I need to consider here today? Are we sure? This is your last-ditch effort? Yes. I mean, all right. Sounds good. So then August 10th, we will be back here, and I will see you guys then. We are adjourned.